They're going to deceive. Now, Sun Tzu said all war is deception. And that's false maneuvers, feigned attacks, pretty much everything we summarized so far in 1 through 3. And one of the things I find really unique with that element is that they will, just like in D-Day, they used deception when they were invading Normandy. There were dummy tanks, there were plastic paratroopers. They were trying to deceive the enemy on when and where they were going to attack the Normandy coast. Same thing with your trial, with your personal injury case. One of the things they like to do is called, before trial, they'll stipulate to a fault, or what they call liability. Now, liability is a three-pronged process. And what they'll do is they'll tell the judge, hey, judge, we admit fault on your case, on this case. Okay, we understand that our insured was the wrongdoer, and so we're going to admit fault. We're good guys. And the reason why they want to do that, and it's usually right before trial, is because they want to come across as being repentant. And what does that mean? Well, when you're being repentant, there's three prongs to that. It's really, when you commit a wrong, you want to make up for it. You have to make up for what you did wrong to someone. That's our rules in society. So when someone says or does something that is wrong and causes you harm and injury, they first have to recognize that they were wrong, admit fault, which is what they're doing here with that proposal. But then there's a second prong, and that's really to apologize. And then number 3, make it right. So when they stipulate or say they're admitting fault, they're not going to also apologize, and they're not also going to make it right. And that's deceptive. So this is a really big deception that they're going to employ on your case, and they'll do it on the eve of trial. And I tell the judge, look, the defense can stipulate to fault all day long. I'm not going to do that. They can agree that they were at fault, but I'm not going to stipulate to fault, because that requires an agreement between the defense and myself. And the reason why I do that is because I want to bring in the wrong act. I want to bring in the facts of the wrongdoing to the jury so they can understand and appreciate the safety rule that was violated. Because without that, you don't have that foundation and context for the jury to make a reasonable inference on the harms and losses. And that's why they do it. So they try to say to the jury, oh, we admitted fault, but they leave out these two elements. And my job as a trial lawyer is to explain to the jury that they left that out. You know, my client never got an apology and he was never made right. So why are we here? So that's the thing that I wanted to point out on that deceptive maneuver that the defense does.